Leanne and Mark were both mowing on without asking.
Do you think they deserve nothing for all that?
I don't think that it would be fair for me to say I should pay you money for something that they asked us if they could do. There was no compensation ever talked about. Anybody could just go mow anybody's house and then send them a bill in the mail months later because they got mad at them and then take them to court.
Welcome to Bench Report Court Cam.
Good afternoon, everyone. This is Judge Middleton. I'm at the courthouse in Centerville. Miss Arnsby, if I get you to unmute.
I'm here. Good afternoon.
All right, good afternoon. Miss Winchell, can you hear me?
Yes.
We're a little early, but let's just get right to it. You're each here on a small claims matter. Miss Winchell is suing for $600. She has sued Brandy Lynn Arnsby and Tristan Arnsby, but we don't have service on Tristan Arnsby. So this matter is just regarding Brandy Lynn. It's claimed for $600. You are in small claims court. In small claims court, the rules are different. They're more relaxed than the general division of the district court. Neither party is allowed to have an attorney. There's no formal record being made of a small claims proceeding. There is no appeal from a small claims proceeding. Any decision made here is final, and there is no appeal. Either party has the right to remove the matter from the small claims division to the general division of the court. You have to still tell me before we begin. Once we begin here, Ms. Winchell, any decision is final. Do you understand?
Yes.
Ms. Arnsby, you understand as well? All right, well, let's put you both under oath. Are you Tristan Arnsby?
Yes, I am.
All right, why don't you raise your right hand too? All right, you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
All right, I read the pleadings and I looked at the telephone text messages. Ms. Winchell claims that there was some sort of agreement with the Arnsbys to give a lawnmower in exchange for mowing this property on Clark Street in Mendon. And the mower was never transferred, so she is sued for damages of $500 plus court costs. Miss Winchell, why do you believe that they owe you $500?
Well, their property, we had to come to an agreement with to mow. It was very tall in length, their grass. It was, I'm 5'2", and it was past my knee at the first cut. That first cut took us 4 to 5 hours in multiple passes.
Well, let me ask this. Why were you responsible for mowing this?
My boyfriend and I were mowing the property because Brandolyn and I came into an agreement for me to take care of this property by lawn mowing for an exchange for a mower or cash.
All right, that's where this case has problems. We have to find there's some sort of an agreement. I'm not sure we got there yet. What kind of lawnmower are we talking about?
It was a Cub Cadet riding lawnmower.
And how did you and Miss Arnsby come to know each other? You were the real estate agent that brokered the sale of this house?
I'm also her cousin.
Okay. Did you broker the sale of the house?
I was helping them with buying the house as their agent.
All right, so you were the buyer's agent?
Correct.
Just in Mendon yesterday. I understand this house was in bad shape and had to be gutted or emptied before anybody could do anything. Is that true?
Yes.
All right, in your text, you're in a yank to get over there and mow this place. But they're like, we're not ready yet. We haven't got everything out of there and there's still junk in the yard. And I didn't get all the way back to somehow you said there was an agreement between you and Brandy Lynn to mow this. Tell me when and how that happened.
Right. So our agreement was actually through a phone call through Facebook Messenger back, I believe, at the beginning of July, if not at the end of June. Once they were to get possession of the property, that's when the lawn taking care process was supposed to begin. But that was over a phone call, and I don't have records of that phone call.
Well, in your pleadings, and that often we struggle right off the bat. Brandon Lynn and I entered a verbal agreement of services in exchange for a particular item or cash. So when we're talking about a verbal agreement, it often becomes he said, she said. The service was for lawn care work on flipping their new house in Mendon in exchange for a lawnmower or services given. So was this lawnmower purchased with the house?
No.
All right, you guys brought a Cub Cadet mower over there?
My mom was giving me the lawnmower. At the time that we purchased it, I was living in Washington State, so I had not been to the property yet. There was no verbal agreement that I would ever give her my lawnmower. She asked me if she would be able to borrow the lawnmower because her boyfriend, was starting a lawn care business and he really liked that lawnmower and they needed more lawnmowers. I told her as a family member that, yeah, sure, she could borrow my lawnmower if they needed it. I came to find out later that they had 5 lawnmowers already and didn't need it. They kept asking me if they could mow the lawn, and I kept saying, we don't need our lawn mowed. We had a house that was unlivable. We're in the phase of just like taking all of the insides out and throwing everything from our house into the yard at that point because we had a full renovation to do. So we didn't need our lawn mowed, and we had a lawnmower.
So you brought this property sight unseen from Washington?
Yes, Your Honor.
I'm trying to picture which house it is. I guess I could have looked it up. I probably drove past it yesterday. How did you come to buy this?
We found it on Zillow. My family is originally from Bronson, and so we were looking to move back and purchase property. My husband, Tristan, does construction, so we took it on ourselves and remodeled the whole thing.
All right. When did you move back?
Beginning of August.
Of 24?
Yes, Your Honor.
All right. When did you purchase it?
It was June or July when we actually purchased it. Leanne, do you know the day?
About mid to late July.
All right. And then you moved back here in August?
Yes.
In the exchange of text messages, I don't see any agreement for this. Good morning, Muffin. I was wondering if you could leave the key for your house this weekend so Mark and I can go inside if we need to when we mow tomorrow. So something precedes that. That's August 2nd. So who is Muffin? Brandon Lynn?
That's me. Yeah, we did. So when we purchased the property from Leanne, it was her first house that she was selling, and it was the first house that I was buying. So we went on that journey together. And during one of our phone calls during the purchase agreement phase of buying the house, she said in her own words that her boyfriend has OCD and really wanted to mow the lawn because he'd been out on the property with her during that process, I guess. I'd not been here, and asked if they'd be able to mow it, and I did allow them to mow it the one time. The second 2 times, I did not give consent for them to mow my lawn.
Okay.
I also,
All right, I don't think we're ready to mow yet. We haven't cleaned out the yard for you. We almost finished throwing all the trash into the house. We'll have a dumpster by next week. I do have a favor. What a shit out there. Almost everything out. Then we're into August 10th. So, all right, there's another theory under the law in quantum merit, where they did work and they ought to be able to be reimbursed for it.
so, Your Honor, if I may,
Yes.
come to our house one day because they asked if they could help us with the house. We said, sure, you can come over and help us with it. When we got to the property, Leanne and Mark were both mowing on without asking, and we said, that's not what we asked for. And they said, well, we're almost done, and then we'll help you. And then they helped us for a couple hours at the house. We took lunch. We paid for their lunch, said thanks for coming to help. Everything was at that point.
Well, you make it sound like you're doing them a big favor. Hey, we allowed them to mow our lawn. The village of Middleton probably doesn't like having knee-high grass on this house right in the middle of town on Clark Street with junk all over in it. And so maybe he is OCD and could stand to see it like this. But you're like, we allowed him to mow it one time, like somehow that was generous of you. As she said, it probably took 4 or 5 hours to cut it. So the first time you say you allowed them to mow it, then the second time they were mowing it, and then you got there, they were mowing it with that Cub Cadet mower.
No, they had brought some push mowers over from, I guess, their house. I'm not sure. We never discussed them mowing our yard at that point.
All right. So do you think they deserve nothing for all that?
I mean, I don't think that it would be fair for me to say I should pay you money for something that they asked us if they could do that first time. There was no compensation ever talked about. So that I feel a little bit like I don't totally understand the law, but it kind of seems to me like then anybody could just go mow anybody's house and then send them a bill in the mail months later because they got mad at them, and then take them to court and then ask for money. I don't see how that.
All right, well, that is true, but you aren't just anybody. You're related. You had a relationship. You exchanged texts about it. There was no meeting of the minds. There was no contract with offer, acceptance, and consideration. However, this is a bunch of hard work twice. And it's like, well, sorry, you offered to do it. Too bad. Then they get mad. She thought there was some deal for exchange of the mower. You, on the other hand, had no clue that there was a discussion about giving them the mower. So she had one mindset, you had another. So you didn't have an agreement on what the deal was. But there's this other theory called quantum merit, that if you do something, you should be able to be compensated for it. She already gets her court costs. I'm going to split this in half. I'm going to order half of $500, which is $250 and $66.25 in cost.
Okay.
You guys probably aren't going to have Thanksgiving dinner together. It's too bad it came to this. You owe $316.25. And as I indicated, the village of Middleton probably didn't like this. So the house has been refurbished now?
It's still in the process. It's almost done. The first floor is done. We're still working on the upstairs. So
Is this the great big brown one?
No, it's a little white one. There actually were the people who owned the property before us were drug users in the town that had warrants out for their arrest. The police were involved in the whole matter, and then they were squatting on the property after we purchased it. So the town actually was okay with the mess for a while because they were just
one mess is lesser than another mess. All right, that's my finding, $250, I cut the claim in half. 66.25 in court costs. The damages are only to Brandon Lynn. There was never any service on Tristan Arnsby, but he's in the same position. You did not have a meeting of the minds. You did not have a contract. Work was done with your consent without a meeting of the minds, but work was done, and that's the quantum merit theory. So I'll send you a copy of this judgment. You just send her a check within 30 days. The matter will be completed. All right, you're both good to go. Thank you.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.